Hi, everyone. In this PowerPoint, we're going to talk about something called alternative dispute resolution. Hopefully, you've already had a chance to listen to the PowerPoint on how a civil lawsuit, the civil litigation proceeds. That was the one right before this one, and read the section in your book on civil litigation. There's also a small section in your book on ADR or alternative dispute resolution, but I, again, like with all other sections, want to give you guys just a few important highlights from that section. So this is a really long, fancy name, alternative dispute resolution. It's a fancy way of saying resolve our legal problems without going through litigation, hence the name alternative dispute resolution. So why do we even have such a thing as ADR? Well, it's really a response to civil litigation and that other PowerPoint I described to you. We described that litigation is the process that takes place in the court system with the plaintiff and the defendant resolving their legal dispute. And that is our system. We know that. That's the judicial branch of government. That's how we resolve conflicts. That's how our common law develops through court cases and precedent. But that doesn't mean that that system is perfect. In fact, as I pointed out on the earlier PowerPoint, and as mentioned in your textbook, there are a couple of pretty big problems with our litigation system. One of them is that it's really time consuming. Remember, we talked about that process of discovery and how it can take even a year or two just to make its way through the discovery process. What does that mean for a business owner or an individual who has a legal dispute? What it means is that it could literally be 3, 4, even 5 years from the time the conflict arises until it's resolved. That's a really long time. And most people, businesses, entities, we don't really want to wait that long. And so the time-consuming nature of litigation is a really big problem. The other problem is that it's expensive because for all the work the attorneys do on your behalf and the client's behalf, they charge the clients. So it also was really expensive to conduct litigation. So for both those reasons, you have both it is expensive and it's time-consuming. We have an alternative method, and that's alternative dispute resolution. So there's a couple different types of ADR that are used, and I'm just going to quickly go over the highlights of them because I know they're described in your book as well. So the first one is called mediation, and the second one is called arbitration, and they are different from each other. So again, here's like a little PowerPoint with just some of the key differences. Number one, when we talk about arbitration, I'll actually do arbitration first. Arbitration, the decision to go to arbitration versus litigation. So again, you can see me in the video. It's like a path. If you go down the lawsuit route and you go towards civil litigation, then you're not doing either one of these. But let's say you have the opportunity to choose one of the ADRs, either mediation or arbitration. If you go down the arbitration path, sometimes you don't have a choice. And I wrote there often mandatory, which means sometimes individuals actually have a written contract. And in the contract, it says if there's a dispute over this contract, the parties must go to arbitration. I'm going to come back and talk about mandatory arbitration in just a minute. But for now, keep in mind that sometimes we don't have a choice. We have to go to arbitration. Other times, the parties can choose arbitration. But once you choose arbitration and go down that path, you don't then go to litigation. So if the parties go to arbitration and one doesn't like the result that they got, they don't get to say, oh, now let's go back to court and go back to the court system. It doesn't work that way. Once you go down arbitration, you're with arbitration. So as we mentioned, arbitration is a type of alternative dispute resolution. And what you have instead of the judge and a jury is you now have individuals called arbitrators, and they are appointed. Now, there's a process to appoint them, so it can be a fair process. And there's either one arbitrator, you could also have a panel, maybe 3 arbitrators. They're supposed to be neutral entities, like not siding with the plaintiff or the defendant. And they're not judges. So you don't, one of the things about going to alternative dispute resolution is that you've now left the court system. Like I said, you went from your litigation court system and you're now down a different path. So there's no more judge, there's no more jury, and the case will be decided by an arbitrator. Now, the arbitrator's decision is considered final. There is one method to appeal an arbitrator's decision, but it's really very limited and it's very difficult to do that. I'll talk about that on the next slide about appealing an arbitrator's decision. But just keep in mind, if you go to arbitration, it's your conflict, your civil dispute is resolved by an arbitrator who is appointed, who's supposed to be neutral, and her decision or their decision is final. There's not a path to a trial. You don't get a do-over in a court system. There's no jury. Another thing about arbitration that is a negative is that it's not open to the public. So we can also contrast that with something like the court system. The court systems are open. The public can come in and watch any civil trial. We don't have private secret courtrooms in the United States, but arbitrator decisions are private. You can't knock on the door at an office and say, oh, hey, there's an arbitration. Can I come in and watch it? So it's private. So that's the arbitration path. Mediation is another type of alternative dispute resolution. It's actually used very often in family law. If you or anyone you know has been through a divorce proceeding, it almost always involves a mediation. But you can mediate other disputes too that don't involve family matters. You can mediate a contract dispute or something else. Mediation is always voluntary. So that makes it a little different from arbitration, where sometimes there's an obligation to go to arbitration. Mediation is often suggested by a judge to say, hey, listen, you with your contract dispute, this does not sound like a complicated lawsuit. Let's not take this all the way to trial. I'm going to send you, the plaintiff and the defendant, to a mediator who works out a compromise really between the two parties. So mediation, the idea is like that one mediator works with one of the parties, finds out what's going on with her, then goes to the other party, tries to find out what's going on with him, and kind of goes back and forth to see if the parties can resolve the case without going to trial. And if they can, that's great. So then they've just resolved the case and they don't have to proceed to civil litigation, the trial system. But in mediation, if the parties can't resolve the conflict with the mediator, then they can still go to trial. So just to recap, if you're on that path where there is a conflict between a plaintiff and defendant, remember, just civil, not criminal, none of this works in criminal, then the parties can deviate. They can go away from the civil litigation path, and they can either go down the arbitration path or the mediation. If mediation resolves the dispute, great, the case is over. If the mediation doesn't resolve the dispute, then you're right back on that path to the civil litigation and trial. Arbitration, I want to mention something about it being different. Now, this is your not homework. Homework is to find yourself in a contract that you have, find a mandatory arbitration clause. And if you want to do this for your legal news assignment, you can look this up too. This is a really hot issue right now, is that a lot of contracts put in their clauses mandatory arbitration. I bet you have one in your cell phone contract, your cable TV contract. Many of you might even have it in an employment contract. And if you have an arbitration clause in a contract that you have, what that means is if you have a dispute related to that contract, let's say you have a contract with Comcast or Verizon or Xfinity or RCN, and you want to sue them over that dispute, that would be a civil litigation. But because you have that mandatory arbitration clause, you are forced into arbitration. You don't have the choice to take your case to court. So think about that just for a minute. I didn't make a slide about this, but one of the things I really want you to think about in this section is what are the benefits of going to court, like open trial system, jury of your peers, one judge who's appointed or elected to preside over the case. But there are benefits to arbitration too, because it resolves the conflict cheaper and faster, but there's no jury and it's closed door. So there are benefits and drawbacks to both. And I think actually put a couple articles here on Blackboard for you to read as well. But there is a big movement to get rid of mandatory arbitration because a lot of us don't realize that we waived our right to take our case to court if we have a conflict. Okay, one other thing that I do want to talk about when we talk about arbitration is this guy. Oh, so actually, this is basically what I just said. Is it bad? It's not all bad. You can argue either way. Is mandatory arbitration a good thing? Is it a bad thing? But let me move on to the last slide. Sorry, I forgot this slide was here. All right. Remember this guy? Yep, no longer playing for the New England Patriots, so you can scratch that hat off. But I'm sure a lot of you remember when this happened, or you at least have read about it. It was a conflict involving former New England quarterback and six-time Super Bowl champion Tom Brady. Several years ago, I want to say, oh my goodness, I'm losing track of years, 2014, he was accused of deflating footballs in a championship, in a playoff game, in an AFC championship game. And who accused him but the other team? So the reason I bring it up here is because the Tom Brady Deflategate case involved mandatory arbitration. So how did that work? Well, Tom Brady was accused of deflating footballs, which is a violation of NFL rules because you're not supposed to do that. And it was supposedly giving him an advantage because he could grip the football better in colder weather. Well, the commissioner of the NFL is a man named Roger Goodell. And at that time, he said to Tom Brady, yes, I think you did this. And he ordered Tom Brady to a 4-game suspension, or to a suspension of some games as a punishment. Well, Tom Brady didn't like this too much, right? He's not just going to say, oh, yes, I did this crime, I'll do the time. So what he did was he wanted to challenge it. Well, Tom Brady is a member of what's called the NFL Players Association. And that's a union. So every player in the NFL is a member of the union. And you know what the union has? Is a contract. And guess what that contract has in it? You got it, a mandatory arbitration clause, which means that if there is a dispute relating to a matter of that contract, the matter goes to arbitration, not civil litigation. So a very long story short, and believe it or not, it is a long legal story. Tom Brady arbitrated his suspension. Now, what made the case super interesting from a legal perspective is guess who the arbitrator was? Maybe some of you remember this. It was Roger Goodell. It was the head of the NFL. So not only was he the defendant, sort of, and the lead investigator, sort of, into this whole dispute, but he was also the de facto judge. He was the arbitrator. But this was all allowed by the Player Association rules. And as you can well imagine, Roger Goodell said, no, you're taking this suspension. Tom Brady appealed it to a court, which is that piece I mentioned that generally you can't appeal arbitrator decisions, but it's very limited. And Tom Brady, first he won in court and then he lost. And you may remember that he began, I think it was the 2015 season. He began the 2015 season, I think it was, with a 4-game suspension. And then, as if the movie gods could write this story, he then came back and went on to win the Super Bowl that year. So it makes for a really great both legal story and sports story. And I know I went through that really quickly, but I just want to use this as a really good example of how arbitration is everywhere. And a lot of companies and entities put mandatory arbitration clauses in their contracts so that they do not, the companies that is, don't have to pay the time and expense to take matters to court. And they force everyone into arbitration. Now, again, there are a lot of benefits to arbitration, but there's drawbacks as well. So take a look at your section of your book on this. I also gave you some stuff to read about mandatory arbitration, and it also compared that to mediation. So that's the end of this PowerPoint. I'll see you all on the discussion board for this unit.